final session of the day. The semi-final, yes. It's final, yes. Really is the survivors who are here now, the true survivors. Well, welcome to this session on education. I'm Bruce Sievers. I was the research analyst on the Education Committee of the Constitutional Convention. I want to first join my colleagues in thanking May Nan and Evan Barrett also for their terrific work in organizing this, and Evan for the great work he has done and is doing still on doing the videos of the various topics to create a lasting video of the convention and of the history of the Constitution. Also, I just wanted to say also that what an incredible privilege it was, and I feel so lucky, like my colleagues, in having come along about 1972 when all this was beginning to happen. Just so happened that a group of us, and I would suggest also name my other colleagues, Roger Barber, who just preceded me, Rick Applegate, Jerry Holleran, Jim Grady, all who went on to do important things in their careers. And Rich Bechtel also, we were hoping to get him back here. He's in Australia now, so that's a little bit of a flight. Anyway, so it was an incredible experience. I must say, it was a formative one for me in my life. And I think it is a rare opportunity that we had to come together with colleagues and with all of the delegates at a time when we were really shaping or helping shape the future of a document for the state and an important event in the history of the political life of Montana. So at that time, and if you wind the clock back into the 19th century, you think of the Montana educational system as really a beginning of a bunch of scattered local schools, much like the entire United States educational system, but even more so. So scattered around the state in a big territory, developing under a system of local control and decentralization that gradually morphed into now what we see today as a modern, coherent, and quite progressive educational system. That process has been a long one developing, but has turned into a very interesting and well-organized system. When we're considering the education issues in the Constitution, the first issue that comes up is like the finance issue, should education even be a part of a constitutional process? And there are a couple answers to that. One is that, well, maybe not. Here's what I wrote in actually the beginning of the study of education, of the issues of education in the Constitution of Montana. Constitutional revision in the field of education begins with the question, does education belong in a constitution at all? The answer is not inevitably yes, because education as a substantive area is not inseparably a part of a governmental framework. If the answer is no, however, this study will have completed its work in the first paragraph, and the reader need go no further. But of course, it went another couple of hundred pages, so obviously there was more to talk about than just that, just should it exist or not. And eventually the Education Committee began to focus around a number of key issues in the field. We'll talk about a few of them today. We certainly won't try to cover everything that the committee discussed and that are appropriate issues for education. But there were, I would suggest, at least 4 key questions that the committee focused on. And we'll talk about those today. One was this question of the right to a quality education versus the right to an equal right to an education. So you have the classic opposition in American culture between quality and equality, and trying to attain both of them financially is a great challenge. So let me first of all turn to the first of our panelists. Let me just quickly introduce them. Again, you have something about them in your program, but we have Jim Molloy, an attorney who litigated the right to equal quality education under the Constitution. We have, who will be speaking second is Rob Watson-Wright, who is he was a former school administrator. It was most of his career, and is now the executive director of the School Administrators of Montana. We have Mary Sheehy Mo, who herself is a former teacher. I think she split her time between teaching and then later on in her career under beginning with local schools and then moving to the larger state venue of education. So she became ultimately the Deputy Commissioner of Higher Education in the state, and she was a former state senator as well as a city commissioner. And then finally we have Dave Bedey from the Montana House of Representatives, who chairs the Education Committee there. Did I say that right? Yeah. We're, again, lucky to have all these folks have vast experience in the field and really interesting insights on the question of the provisions of the Montana Constitution and how that has played out over the years. And ultimately, we hope to ask them how they think it might play out in the future, if there are other areas that we need to focus on. So first of all, let me introduce Jim, and then we'll move on.
Thank you. My name is Jim Molloy. I want to first thank Evan Barrett and May Nan, as well as the Constitutional Convention Committee for putting this all together. It's a true honor to be here today to talk about the history of school funding litigation. Can everyone hear me? Is that better? Okay, is that better? This situation with respect to school funding in Montana has a long history. And I will kind of highlight it for you, but I'm going to keep my comments here to 10 minutes or less. In the 1980s, I returned to Montana after clerking at the DC Circuit Court of Appeals in Washington, D.C., and joined the firm that was then known as Getz, Madden, and Dunn. At that time, a lawsuit had been filed challenging the constitutionality of the school funding system that existed at that time. And I had the privilege of working with Jim on that case and worked hard to prepare it. We went to trial. The trial lasted 6 weeks. And it was before Judge Lobel in the 1980s. And he ultimately issued a pretty comprehensive set of findings of fact and conclusions of law that ruled in our client's favor. The matter was then appealed to the Montana Supreme Court, which then issued a decision which was dated February 1, 1989. The decision was predicated upon Article 10, Section 1 of the Montana Constitution. And I'm going to read that to you because I think it is a great provision in our state constitution that guarantees a quality education system for every student in Montana. Section 1 states that it is the goal of the people to establish a system of education which will develop the full educational potential of each person. And this is a particularly important line. Equality of education opportunity is guaranteed to each person in the state. Article 10, Section 2 states as follows, and I'm going to come back to this later. The state recognizes the distinct and unique cultural heritage of the American Indians and is committed in its educational goals to the preservation of their cultural integrity. And subsection 3 states as follows: the legislature shall provide a basic system of free, quality, public elementary and secondary schools. It then says they may provide such other educational institutions as they choose. And then it concludes with this: it, being the legislature, shall fund and distribute in an equitable manner to the school districts the state's share of the cost of the basic elementary and secondary school system. So those constitutional provisions were the linchpin upon which we litigated the Helena Elementary School District case. After Judge Lobel's opinion or findings and conclusions were rendered, the case went to the Montana Supreme Court, and we prevailed. And I'll just highlight a couple of the quotes from that opinion. The Montana Supreme Court says, "We hold that the 1985-86 system of funding public elementary and secondary schools in Montana is in violation of Article 10, Section 1 of the Montana Constitution." That was a particularly important holding, which led to some further issues. In that same decision, the court also said that the accreditation standards are the minimum standards upon which a quality education is to be built. They do not define a quality education. And essentially, the court's order was that it's the legislature's responsibility to now define what the components of a quality education are, and having done so, to then fund it adequately. So following that opinion, the legislature met and they passed some new legislation in the 1991 session. And Jim Getz, with Brian Gallick's assistance, then filed a second lawsuit. And I was retained, together with my brother, the Honorable Donald W. Molloy, to litigate on behalf of the Montana Rural Education Association. And the state of Montana moved to consolidate those cases, and Judge Sherlock said, no, we have distinct issues here, but there are some issues in common. And so both cases were prepared. Depositions were taken in conjunction, not separately. And the case went to trial before the Honorable Jeffrey Sherlock, a highly respected judge. They were tried from January through March of 1993. There were 2 different trials, but then an overlapping set of evidence as well. So following that, Judge Sherlock denied the state's motion to consolidate the cases And then on April 24th, 1993, the Montana Legislature passed a bill known as House Bill 667. And then the state of Montana came in and moved to dismiss those cases on the grounds that they were rendered moot by virtue of the fact that the legislature had enacted a new bill that totally restructured how school funding would happen. Judge Sherlock agreed with the state's position on that and dismissed our cases as being moot. So that takes us to our next round. So after that bill was passed, several years went by, and I was contacted by the superintendent of public schools in Columbia Falls, a gentleman named Mike Nicosia. He's a very impressive guy, but very quiet. And he asked me to conduct an analysis of whether we could challenge the school funding system that was then in place, which I did. I prepared a memorandum. I went up and met with the school districts in the Flathead County area, and that launched an effort to move forward and file yet another lawsuit, which became known as Columbia Falls Elementary School District and others versus the state of Montana. But before we could do that, we needed to get support from other school districts and, frankly, from the teachers union. And I'll tell a quick story on that. We traveled around the state, made presentations, and then we had a meeting at MEA MFT. And we're in a meeting room. I make my presentation. I had a full memorandum and everything. I presented it to everyone and talked about what our theory would be. And it was a good discussion. And then Eric Fever said, "Everyone out of the room, Molloy, you stay." I thought, okay, I know what's coming. And he said, "What are you doing suing the Butte Teachers Union and the Butte Public Schools?" And I said, "Eric, I used a different word, but they did not treat the retirees fairly. And by the way, the Butte Teachers Union has now been taken over by my clients, as has been the school board by my other clients." So it was a fun interchange. MEAMFT said, yes, we're on board. We then filed that lawsuit. It went to trial before Judge Sherlock, and we got a favorable decision. And he issued extensive findings of fact and conclusions of law, which were very impressive, well prepared, partly due to the work that Brian Gallick and I did in submitting them. And he ruled in favor of the plaintiffs, declaring the then existing school funding system to be unconstitutional. That decision was then appealed to the Montana Supreme Court on March 22nd, 2005. The Montana Supreme Court addressed several issues, one of which was political question, and they rejected the state's argument that this was a political question. They also addressed other issues, including Article 2, or subsection 2 of Article 10, the Indian Education for All article. And I want to tip my hat to Norma Bixby and Carol Juneau, both of whom testified at our trial, and then sponsored legislation to try to fund the Indian Education for All subsection of Article 10. And that was great work on their behalf. Quite a bit has been done for that in the meantime, but my perspective is it's still underfunded. My wife would know more about that than I do, but I do believe that That is a really important part of our state constitution, to recognize the distinct and unique cultural heritage of American Indians in our society in Montana. So we prevailed at the Montana Supreme Court, and some time passed, and I'm not going to disclose attorney-client communication here, but we were instructed to file again for further relief in the district court, which we did. We went to trial. We tried the case from September 22nd through the 26th, and on October 22nd, 2008. And Judge Sherlock issued a very thoughtful, blunt set of findings and conclusions in which he said that, yes, we had demonstrated that there were continuing issues with respect to whether the current school funding system was fully satisfying the legislature's obligation, but that he would defer to the legislature to continue to work on that. And that kind of closed the books on the litigation, and there has been no further litigation since then, other than I am aware that there right now is litigation challenging whether the legislature is fulfilling its obligations under Article 10, Section 2, with respect to Indian education for all. That's an issue that is being litigated now, I believe, by the ACLU. So that brought to close, at least to date, all of the school funding litigation. Then there's one other case that I need to address, and that is the Espinoza opinion. And Montana has a provision in its constitution which is pretty unambiguous: aid prohibited to sectarian schools. And it reads as follows: the legislature, counties, cities, towns, school districts, and public education and public corporations shall not make any direct or indirect appropriation or payment from any public fund or monies, or grant any grant of lands or other property for any sectarian purpose, or to aid any church, school, academy, seminary, college, university, or other literary or scientific institution controlled in whole or in part by any church, sect, or denomination. And then it has another section that says it does not apply to funds from federal sources provided to the state for the express purpose of distribution in non-public education. The district court ruled, I'm sorry, my phone's ringing. The district court ruled in favor of some parents of students at a private school up in Kalispell. The Montana Supreme Court reversed that. The case then went to the United States Supreme Court. The United States Supreme Court held in the Espinoza case that the free exercise clause supersedes Montana's provision prohibiting sectarian aid to private schools. And I'm not going to comment further on that at this time. With that, I'm done with my presentation, and I'll turn it over to Rob.
Just one quick comment on that. That is, we could spend the whole session, actually several sessions, on the church-state issue, so, which was a significant point of conversation at the convention, but I think Jim covered it very well, and we'll have to do that another day.
Thanks for the opportunity to speak today. I have to recall my teaching days. You're looking a little bit like my 7th period class on a Friday, who really wanted to be anywhere except with me on Friday afternoon. And I often would tell them, you know, maybe you need to get up and run around your desk a little bit just to wake yourselves up, or run around the school once, but I tried that once and they all left, surprisingly. So thanks for the chance to speak today. Thanks to the delegates, the interns, and the research analysts that are in attendance today. We are forever grateful for your work on our Constitution. For the record, I'm Rob Watson. I'm currently the superintendent of schools for Missoula County Public Schools for a few more days. On July 1st, I'll take over as the Executive Director for the School Administrators of Montana. I just completed my 29th year in public education. While my time has been challenging, especially the last few years, I've also said it's been extremely rewarding, and I'm thankful for the years I've been given. It's an honor here to speak to you today, but I do have to reflect. I have to be honest with you. I should not be here at this podium today for two reasons. First of all, I was not part of the original convention. I was only 2 years old at the time, living in Miles City, and didn't know much about the convention. Also, I'm not an attorney nor a historian. In fact, I didn't even teach social studies or history. I actually taught math, and I love to teach math because there's no controversy in math. It's either right or wrong. There's really no debate or controversy. So I always used to give my social studies colleagues a hard time because I thought I had it pretty easy that way. The second reason that I should likely not be here today in front of you is that it has to do with my family history. And if you'll allow me to explain a little bit, I promise we'll bring it back to the point at hand. So my mother was educated in a one-room schoolhouse in Miles City, Montana. It was actually outside of Miles City, Montana. If you're interested to see that one-room schoolhouse, you can go to the Historical Museum in Miles City. They actually picked it up and moved it to Miles City several years ago. Her parents were immigrants to the United States. Her mother was a migrant farm worker from Mexico, and her father was from the Philippines. They actually met, fell in love, had 6 kids in Miles City, Montana. That's a whole nother story that I don't have time for today. My grandparents came to Montana because they wanted a better experience for themselves and their family. They knew the value of education. My grandmother once told me that she believed her job was to make sure the kids were fed and had clean clothes and got to school on time. That was her only job, and she took that job very seriously. At the local public school outside of Miles City, my mother and her siblings had access to that equality of educational opportunity that is guaranteed in Article 10, Section 1. But I'm here today to tell you that the equal access and opportunity was not enough. She had access to a highly qualified teacher, but that alone was not enough. Just like every other kid in her neighborhood, she had the opportunity to a rich educational environment. Granted, it was in a one-room schoolhouse, but I think that was a pretty rich environment. But still, that was not enough. Her community supported her by paying their taxes so she could go to school, but that was not enough. Despite all those pieces, equal access and opportunity to education was not enough to help my mother. The deck was stacked against her when she walked through the school doors. By most standards, her family was poor. While her father had a good job, there were 6 kids to feed. English was not their first language, and was often not spoken in the home. Her parents were undereducated and struggled with reading and writing for most of their entire life. And then on top of all that, raising 6 half Mexican, half Filipino kids in rural Montana in the 50s could not have been easy. My mother and her family experienced hate, trauma, challenges, just like many of the children that we work with today. But don't worry, this story has a happy ending, otherwise I probably wouldn't be standing in front of you today. For there was a superhero in the story, someone that understood that kids need not only access to education, but also focused attention on their unique skills and abilities in order to fully succeed and reach that full potential guaranteed in the Constitution. Miss Mosby was the dedicated teacher in that one-room schoolhouse and the hero of my story. In addition to teaching, Miss Mosby also fired up the cook stove in the morning to heat the schoolroom. And at the end of the day, she cleaned the schoolhouse at the end of the day. The beauty of Mrs. Mosby's work was her ability to understand that all kids come to school with different skills, experiences, and backgrounds, and those differences impact their ability to learn. She quickly realized that my mother would not reach her full potential without extra support and intervention. She knew that her job did not end at providing that equal education, but she knew she had to go above and beyond. During the day, she taught my mother and her siblings how to read, and then after school, she taught my grandmother how to read. And she did so because she understood that the impact, that the mother's education has a direct impact on the future success of the child. Mrs. Mosby was a hero, but she was not unique. I'm here to tell you that today that there are heroes across the state working with our kids each day, going above and beyond to make sure that they meet the unique needs of our children. So this is why I believe this story is relevant to our celebration today. When I was asked to comment on Article 10, I have to tell you that I felt very undereducated. I wanted to understand the language of subsection 1. Just to remind you, subsection 1 says it is the goal of the people to establish a system of education which will develop the full educational potential of each person. So to prepare, thankfully, Maynan met with me, and she also provided me some history. She provided me with the transcripts from the convention, which helped a great deal. In reading the discussion that occurred at the convention, I discovered an important concept, that language and words really mattered to the delegates. Many discussions, many debates, many amendments occurred regarding the selection or elimination of certain terms. I believe that this rich debate and deliberation created a document that is timeless and remains extremely relevant today. The education article, Article 10, is a clear example of this. At the convention, when they were discussing that phrase, full potential, full educational potential, there was some concern about the word full. A delegate was concerned that full would mean that we'd have to provide kindergarten for all, something we do today, but back then was not. He also was concerned that the word full meant that we'd have to provide adult education for all. Delegate Martin made the motion to eliminate the word full from the language. Fortunately, there were other delegates that weighed in, and I am so grateful that they spoke in favor of keeping it. Delegate Harbaugh perhaps made the most clearest justification for keeping the word full in the language. As you know, the sentence begins with, "It is the goal to develop the full educational potential," which makes it clear that this sentence is aspirational and not necessarily a mandate that would require significant funding. Today, that aspirational statement is something critically important to all of us that work in public education. This sentence provides us with marching orders for all educators and defines some of our most important work, which is making sure that each child has the opportunity to reach their full potential. I am eternally grateful to the delegates for making sure that it was maintained in the language. Recently, I had the privilege to help revise the Montana Educator Code of Ethics. It's also an aspirational document. Our committee that was working on the Code of Ethics was made up of practitioners from across the state. And we made the recommendation to include the word equity in our statement of commitment to students. To my surprise, there was a significant consternation from members of our public and even from some members of our elected officials regarding the inclusion of that word. After listening to the testimony, I'm convinced that unfortunately some have chosen to politicize a word and a concept that is critically important to our work as educators. I would argue with you today that the concept of equity was also important to the delegates and the writers of our Constitution. The brilliance of their work is seen when you look at Article 10, subsection 1 as a whole. Not only did they guarantee equality of educational opportunity to each person, but they also made it a goal to establish a system that would develop the full educational potential for each person. And that, my friends, is the very definition of equity, educational equity. Just like you all, Ms. Mosby understood that it was not enough to provide equality, but she also had to provide equity because all kids came into her classroom with different abilities. Her job was to make sure that each kid reached their full educational potential. Mrs. Mosby's dedication set my mother on her path towards achieving her full educational potential. My mom went on to graduate, the only person from her family to graduate with a 4-year degree. She became a highly qualified teacher in the state of Montana, eventually achieving a master's degree, which was her full educational potential. My sister and I were both inspired by my mother. We both achieved our doctorate degrees and can clearly state that we have done everything we can to reach our full educational potential. So had it not been for that teacher in that one-room schoolhouse in rural Montana who taught my mother how to read and taught my grandmother how to read, I can state with confidence that I would not be standing in front of you today. And had it not been for the foresight and the brilliance that went into the wording for Article 10, I can guarantee that not all kids would be striving to reach their potential. Sorry. And as for the delegates here today, as a dedicated public educator, on behalf of the literally thousands of kids that exist in our system today, from the bottom of my heart, I cannot thank you enough for the language that exists in Article 10. Thank you.
Thank you, Rob, for that very eloquent and moving piece. Thanks very much. I just wanted to also point out that, I guess maybe we'll come back to this, but the reference to Indian education, it was interesting in the discussion of the committee at the convention, that mostly had to do with making sure there were sufficient resources, there were better resources supplied for educating Indian students, and that there would be, they would gain the potential because of those resources. Since then, that interpretation, and I'd be interested in any of your thoughts on this, has morphed into making sure that all the students in Montana had access to information about Indian history and Indian culture. So it was a two-way street, more so, I think, than the delegates originally had sensed. Mary, if we could turn to you.
Thank you. It's a pleasure to be here. I'm thinking that before our last group gets off, Governor Roscoe, you might want to put up a different Russell painting, maybe Waiting for Chinook. It's been a long 2 days, but it's been thrilling. It's been the curse of my life to be running a distant second to Sheila Stearns, who was supposed to give this presentation. Sheila came down with COVID and asked me to step in, and as always, it's my pleasure to do so. If you had set out with the intention of creating a completely dysfunctional governance system for higher education, you could not have done a better job than the framers of the 1889 Constitution. Remember, there were no universities in Montana in 1889. There were public schools, though, and the intent to have a university. The framers figured one board could handle both and creatively named it the State Board of Education. It had 11 members. The governor was a member, and if he wanted, since he appointed the 8 public members of the board, he could be chair. The superintendent of public instruction and the attorney general, go figure, were also members. Although the Constitution required a state board, its powers and duties were to be assigned and could be and were retracted or revised at any time by the legislature. It gets worse. The affairs of each campus had 2 competing governing bodies reporting to the board. One was a Board of Education committee comprised of 3 board members and the campus president. The other was a local committee comprised of 3 local businesses from the businessmen from the campus community, and yes, they were men, appointed by the governor. The makeup of these 2 committees changed from one decade to the next, but their end runs on one another remained the same. It gets even worse. If the legislature allocated more funding to the campuses than was actually in its coffers, a frequent occurrence, a board of examiners made the decision on how much money each campus would get. I could tell you tale after tale of the catastrophes that occurred during the university system's 8 decades under that Constitution. But in the interest of time, I'll focus on recurring themes. Theme 1, Constant zigzags in direction resulted in constant firing of the leaders who zigged when they should have zagged. At what is now the University of Montana alone, 6 and arguably 7 of the first 9 presidents were let go, many without notice or hearing. The university became known as the graveyard for presidents. Theme 2, continual repression of academic freedom and the faculty who relied on it. As one scholar described it, the 20th century, the State Board of Education went on a decades-long spree of Star Chamber proceedings, book burning, suppression of academic freedom, and the firing without hearings of both professors and presidents. Theme 3, hopeful expansion of the system and duplication of programs did not match the reality of the state budget. The 1889 Constitution left the number and location of colleges and universities to the legislature. Right away, Paris Gibson argued for only one, centered, of course, in Great Falls. As always happens, the way to defeat a strong legislative representation from one community is to create a coalition of delegates from other communities that will be left out in the cold if that first community gets the plum. Missoula, Butte, Dillon, and Bozeman did that. Great Falls got left out in the cold, and it's been shivering ever since. It gets worse. Montana was struggling to fund just those 4 units. In fact, although all 4 were approved in 1893, they couldn't open the School of Mines and the Normal School in Billings until 1998 because they couldn't afford to. Unbelievably, in the middle of the depression that hit Montana in the 20s, when 1 out of 2 farmers lost his land to drought, when 4 colleges had been struggling for 25 years to make ends meet, the legislature and governor added 2 more campuses, Billings and Havre. Program duplication and mission drift were also de rigueur. Before the system was even out of knickers, the Agricultural College was introducing programs in the arts. The university was offering teaching programs that were supposed to be the normal school's niche. On and on it went with the usual excuses. There's a greater need statewide than one campus can meet. Our community has a greater need here than your community does there, which all boiled down to we have a legislative delegation that can get it done. The primary result of all of this expansion and duplication was a system too big for its budget. And the primary result of the 1889 Constitution's inane governance structure for higher education was instability, a university system on constantly colliding, always trembling tectonic plates. The delegates who sat in these chairs 50 years ago knew that history well. They wisely chose to establish a Board of Regents and established a firewall in the Constitution itself between the Board of Regents and political and bureaucratic influence. They were wise as well to place a Commissioner of Higher Education in the Constitution and to place the Commissioner's reporting line directly to those insulated regents. How do I know those decisions were wise? The proof is in the pudding. In the last 50 years, we have been served at all of our campus by some exceptional leaders. We attract and nurture outstanding faculty and outstanding students. We generate Rhodes Scholars and Truman Scholars and important research. We generate all the people in this room and beyond it that make Montana not so much a state as one really nice community with really, really long streets. I think the biggest challenge the Board of Regents have faced in the last 50 years was the restructuring in the 1990s. People had been trying to consolidate the system for 80 years by then, but it was just too hard. However, when the 5 vo-techs became part of the university system in the late 80s, the regents and the legislature now had not 6, but 11 distinct campuses, each with big local supporters, all demanding a seat at the table and pushing one another out of the chair to get it. Something had to give. It took a determined Board of Regents, some stellar commissioners, and some pretty amazing campus leaders to get it done. But they stayed the course. We now have 2 flagship universities, each with 3 campuses in its domain, one of which is a standalone 2-year college. The restructuring has been mostly positive. The U of M and MSU share resources that accrue efficiencies for the campuses under their domain. In my view, though, leaders haven't done enough to ensure the viability of the non-flagship campuses. Each of those campuses should have a niche that is enticing and fiercely protected by regents and flagship presidents alike. Instead, some campuses have just languished without a clear identity and with niches they once had duplicated elsewhere. Nobody likes to be seen as poor kin, and in an enrollment-driven system, them it has gets. I also think that over time, the Board of Regents has failed to engage in much of the deep digging and true debate that lead to good decision-making, generally following the commissioner's lead rather than the other way around. Both the regents and the commission seem more concerned with avoiding controversy sometimes than protecting that firewall between political and bureaucratic interference. As with so many of our precious assets, our public lands and even elected office, for example, money talks and mega money screams the rest of us out. We are seeing that with buildings and the university level. When somebody is going to give a whole bunch of money to give you a building, it's pretty hard to say no. But you have to remember that we, the people, maintain those buildings into perpetuity. And maybe we will sacrifice other programs and maybe even other campuses to draw students to it. The recently adopted Regents policy on naming buildings mystifies me. It self-negates when a donor gives a transformative gift. Who are you going to tell that their gift isn't transformative enough? It sort of reminds me of that joke that ends with, "We've already established what you are, madam. We're just dickering over price." But as my dad used to say, it's easy to be virtuous when the wolf's not at the door. Finally, and most importantly, faced with a system that is too big and a legislative allocation that is never big enough, and lulled into complacency by the phenomenon of federally funded student loans, over the last 50 years, the Board of Regents, the Legislature, and all of us have shifted the true cost of higher education to the people least able to bear it, students. When my husband came home from his high school graduation, he entered a house that had nothing in it but a box of his clothes. He worked his way through college in 4 years and 1 quarter and graduated without debt. That's virtually impossible to do now. Too many of our students leave college so burdened by debt, they have to leave Montana to pay it off. And there's a different kind of debt we should be encouraging. I am one of 11 children. 10 with degrees from a unit of the Montana University system, 19 degrees in all. 15 were earned by my sisters and me. Nothing changes the trajectory of a woman's potential and sense of self like a college degree. 9 of us still live here. In our jobs, in our community engagement, and in our public service, we've tried to pay Montana's investment in us back. I want my grandchildren to assume that kind of debt and have the same wonderful life the Montana University system made possible for me and my family. But you framers gave us a framework. It's not just the job of the regents, the commissioner, or the legislature. It's all of our jobs to make sure the system of higher education keeps the main thing, to develop the full educational potential of each person. The 1972 Constitution gave us the tools, but we have to use them. Thank you.
Now we can hear from the legislative point of view about how they're dealing with all these issues.
Well, thank you, and I'm happy to be here in front of you. I've just spent 2 days in legislative committee work, chairing the Education Interim Budget Committee and then sitting on the Legislative Finance Committee. At this point in the day, I'm sure I may be the only thing between you and the next best thing to do. And after hearing my esteemed colleagues here, I would not be too surprised if I hear hisses and boos, because after all, the legislature is has sometimes been the problem here in terms of education, but it's a challenge, and I think that we're up for it, and I think that the Constitution we have here in front of us is a good place for us to be working from. Just to give you some background on myself so you can understand my perspectives, I was born and raised in Hamilton. I represent House District 86, which is Hamilton and the surrounding area, but I was too dumb to stay home for all these years. I spent 30 years in the Army before I finally came home. The Army kicked me out. It was the best thing that ever happened to me. They make colonels retire after 30 years. I came home. I served on school board for 9 years. While in the Army, I was a professor at West Point for half of my career, so I have some knowledge of higher education. And coming to the legislature and having the opportunity to work in education appropriations, which, by the way, isn't all green eye shade thing, because as you all know, every dollar has a policy assigned to it. It's been a wonderful opportunity for me. But in order for me to function, it was important for me to understand the rules of the game, and our Constitution provides a very good foundation for understanding the rules of the game. But one thing I'll say is that our governance model for education in general, I think, has 3 characteristics. It's decentralized. In some senses, it's overlapping. And by its very nature, it creates various entities that, due to organizational theory, you would probably understand, are competitive. They're competitive in the sense that they have their own prerogatives, their own constitutional prerogatives, and by God, you're going to defend your prerogatives as best you can. I think that's by design, and I think generally it's healthy. I mean, Article 10 creates a Board of Public Education with its own specific duties, a Board of Regents. It identifies local school boards, which I would argue are the most powerful entity within our educational system for K-12. That might be debatable, but that's my position. It gives the legislature specific duties. And Article 6 also provides, in Article 6, we provide for a superintendent of public instruction, with largely administrative duties that are established by law, that is to say by the legislature with the consent of the governor. And I can't help but leave I must be careful not to leave the governor out. The governor isn't identified with specific educational duties, but the governor is tasked with providing us a budget, and that's where you start funding education. And so I see the governor as being a major player within our educational system. Now, in the case of, I've been asked specifically to talk about the legislature's relationship with the Montana University system. We could have chosen this for K-12 education as well, but in the interest of time, I'll remain faithful to the duty I was given. The Board of Regents has very specific duties and power within Article 10 of the Constitution, and I'm paraphrasing here only slightly. Government and control of the Montana University system is vested in a Board of Regents that has full power, responsibility, and authority to supervise, coordinate, manage, and control the Montana University system. And as you heard from earlier speakers, this decision made by the framers of the 1972 Constitution was driven by a lengthy history of political interference with the governance of the university system, and I think was a wise thing to do. On the other side of the equation, of course, we have the legislature. And you've heard the legislature's Article 10 responsibilities, but with respect to our relationship, the legislature's relationship with the Board of Regents, and hence the Montana University system, the most significant power that the legislature wields you find in Article 8, and that is our power to appropriate and then also ensure the accountability of expenditures that are made within the state. Now, some would argue that the Board of Regents is essentially a fourth branch of government, and you're almost there, And as a fourth branch of government, if you buy that particular analogy, you will see it as a fourth branch of government will be competing with the other branches because we have a division of power, and that division of power is very real. That division of power was contested shortly after the Constitution was ratified in 1972 in a court case called Board of Regents versus Judge. It's a rather arcane case when I read it, but as I try to, as a non-lawyer, boil it down, the legislature had tried to influence internal Montana University system budgeting by a set of rules that it applied, and the courts argued that that was interference with the prerogatives of the university system. However, in the very same court case, they also affirmed, and here I will quote directly, that legislative control of higher education through the appropriations process. So what we have here as a consequence of our Constitution, and this court decision helps, I think, make this clear, is that we have a kind of a murky line of authority between the legislature and the university system. Great power in the university system wielded by the Board of Regents, but great power wielded by the legislature through its power to appropriate. So how have we negotiated that particular line to effectively fund and provide the best higher education we can within the state? And one of the things that we have done is within the last less than 10 years, but going back a couple sessions before I entered the legislature in 2019, is that during the appropriations process, the Joint Appropriations Subcommittee for Education, otherwise known as Section E, which I happen to right now chair, works with the Commissioner of Higher Education on what we call a set of shared policy goals. It's an agreement, that usually a 1- or 2-page agreement, where the legislature lays out some things that they see as that the legislature sees as priorities for the state of Montana in the area of higher education. And we seek agreement, and then we provide some funding that's associated with that. None of this coercive, because we cannot coerce the Board of Regents to do things. We can only incentivize. Here are some examples of some of the recent items that we have incorporated in our shared policy goals. Language that calls for expansion of career and technical education opportunities across the state of Montana. And with some emphasis on providing opportunities, those 50% of Montanans who don't live in easy commuting distance of our MUS campuses. This is a challenge I think everyone should acknowledge. If you live in Missoula, if you live in Billings, if you live in Bozeman, you have easy access to higher education. Not so much if you live in Darby or Ekalaka. So we're working with a cooperative relationship with the Commissioner of Higher Education and hence the Board of Regents in that area. We have asked that our teacher preparation programs in our universities incorporate instruction for our new teachers on proficiency-based learning, which studies have shown is a methodology, a pedagogy that is highly effective and is adopted by most of the highest performing schools across the world. We also call for increased interface with our tribal colleges, particularly in the area of common course numbering and that sort of thing, to allow easy transferability of credits between tribal colleges and the university system. And with respect to our responsibility in our educational goals to preserve Indian culture, we have, myself and other legislators, principally Representative Jonathan Windyboy, have been working on Indian language preservation program improvements. That is an existing program we have. We believe that the establishment of Montana Indian language linguistics programs within the university system is a great way to assist us in meeting our constitutional obligation. The university system has enthusiastically embraced that particular idea, and we find that this will be useful for work that I'm helping Representative Windyboy with to increase, well, put it bluntly, to preserve our Montana Indian languages. This is Indian language, or Indian education for all has been mentioned here before. I think that's a great thing, but if we're going to preserve or help in our education goals to preserve Indian culture, we must preserve Indian languages. The legislature is working on legislation. We have existing programs working on legislation to improve that. We need the university system support, and we're getting the university system support in that particular arena. Now, I think moving forward, we have to acknowledge that the environment that we have, our country is different, our state is different since 1972, the economy is different, the situation, competitive situation we have with the rest of the world is different than it was 50 years ago. And so I think we have to be seeking always and question ourselves always as to whether we're delivering education in the best possible way. And that's not just higher education, that includes K-12 education as well. Our decentralized method or governance model that we have within our Constitution, in some senses, makes that difficult because we have so many different, in some senses, competing sources of authority. To that end, I'm happy to report that on the June 6th, we convened a meeting of all of the constitutional players here in Helena to talk about what should our goals for education be moving into the future, and how can we work together, how can we overcome any artificial barriers that exist between school trustees and the Board of Public Education, or the legislature and the Board of Regents, that sort of thing, as we move into the future. We're looking at things, emphasis on proficiency-based learning, which I mentioned earlier, emphasis on career and technical education, taking a look at the teaching profession as it relates to if we adopt these different ways of delivering K-12 education, what do teachers need in order for that to be effective. I must say that this first meeting that we had on the 6th of June was very, very productive. It was, you walk into a situation like that, you never can quite tell when you have that many powerful entities coming together. You don't know whether you're going to have kumbaya or whether you're going to come out bloody and perhaps missing one of your limbs. As it turned out, it was great. We intend to convene again. I can't promise you where we're going to go, but I am convinced that all of the constitutional players, and I enumerated them before, the Board of Public Education, the Board of Regents, school boards, the legislature, superintendent of public instruction, the governor, the commissioner of higher education, are on board with seeing what we can do, and I'm confident that we can work within our constitutional framework to continue delivering high-quality education in the state of Montana, and high-quality education that's going to put us in a great position going forward in the future. And with that, thank you very much.
Thank you, Dave. I think from all of this, we could see one of the key contributions of the Constitution is to deal with the balancing the kind of opposing forces there are around almost all of these issues. So between, in Dave's case, we're talking about the constitutional autonomy of the university, which is an important principle, balanced against the need for funding and the need for some kind of oversight from other parts of the spectrum. We also talked about this in terms of the balancing between, again, quality, whatever we're defining as quality education, and equitable education, equal opportunity for education. So much of what the Constitution does and can contribute, and I think does contribute, is that kind of wonderful opportunity to balance opposing forces in this political and social system. Wanted to see if any of the panelists had questions or comments you want to make to each other? No? Mary?
I would like to add, I wanted to stay within my time, but I didn't want there to be any misunderstanding that I think there should be fewer units of the Montana University system. My dad ran for office the year that the population explosion came out, and he and I were standing in a parking lot. I was holding his little matchbooks that you gave out to people then, and somebody said, "Oh, aren't you that one with all those children?" And my dad said to her, "What do you want me to do, kill 8.3 of them?" And the point is that we have these campuses now, and they each serve their communities in really important ways. We just need to figure out a way to make them sustainable, and it's not easy.
Questions from the audience? Yes, Evan? Yeah, go ahead.
71. Okay, thank you. I wanted to ask you this, Mary, in relationship a little bit to what Representative Bedey talked about, which was the authority of the university system over the policy of the regents over the policy of the university system, and the connection being that the legislative role was to work on the budgetary side. It seemed to me that in this last session, we had the legislature reaching to enter the policy arena of management of the university system, not on a fiscal basis or an appropriation basis, but on a policy basis. I think there were 3 or 4 bills that came out of the session that are now in front of the courts, in which the legislature was seeking to impose policy on the regents. For example, dictating that the regents could not say that guns could be constrained on campus for students, and which I think is a policy area and not a fiscal budgetary area. So I wonder if you would comment, they're in front of the courts right now, the propensity of the legislature, some of them, to want to get into the management area, and the passage of a number of bills that seem to be doing that and have to go before the courts now.
I'd be glad to answer that. The Constitution is clear in terms of policy issues. The legislature believed, and I think still believes, that that was a constitutional issue that was a big C constitutional issue, as opposed to a little one that sort of, no pun intended, trumped our own Constitution. It's important to recognize that when the Constitution was adopted, we did not have a guns on campus policy. But we had a terrible tragedy, I want to say, in about 1990. And a young man, this will not come as, or perhaps it will come as a surprise to you, that kids do a bit of drinking at college. And it may also come to surprise to you that there are also lots of depression and lots of suicide at college. And if you're following the news at all, it will not come as a surprise to you that the success rate, if you want to call it that, and I certainly don't, of attempted suicide is very strongly related to the presence of firearms, the nearby presence of firearms. And so the regents in 1990 reacted to adopt the policy that has been in place ever since then. That is their call to make. And I think the thing that impressed me the most about that was the outcry. One of the things that as a legislator, when people were coming to me and saying, we want to have First Amendment rights on campus, I said, well, have you been to the regents? Have you gone and talked to them? Because that's where the public comment should come. If you can't get satisfaction there, then you might try something else, but have you even tried them? And no, they haven't. So I don't appreciate end runs on the existing authority. And so that should have been step one. But when that issue came up this time, the outcry to the regents from faculty and students alike was voluminous, and that very strongly, I think, influenced the regents' decision to take it to court.
Dave, did you have a comment?
Yeah, so as the representative for the legislature here, I feel compelled to offer a comment, and I'll offer two. Number one, I'm not surprised at the court's decision with respect to House Bill 102. There clearly was an issue there of whether this was a legislative encroachment on Board of Regents authority. But there really is a big C constitutional issue here, and it's a conflict between the Regents' Article 10 authority and then the Article 2, Section 12 authority for citizens to keep and bear arms, which is in our Constitution as well. The courts, it was proper for the courts to adjudicate that, and however they will adjudicate that will be something I will find bound to agree with, even if I don't agree with the finding.
Just a comment on Mary's talk about the building of new state buildings. And of course, university systems have been the mega builders. But Francis Bardenove, who was our fiscal saint for 30 years in this body, would always stand up. He always sat in that front desk and would turn around and say, the cost of building these buildings is the cheapest thing you're going to do. The real cost comes after that. And so those are true words, Mary.
Other questions? Yes?
Thank you to the panelists for the wonderful presentation, and thank you for your service to our state and to our public education system. My question is somewhat related to Evans, and it stems from the first panel we had this morning, which covered the allocation of powers among the three branches of government. I don't think Representative Mercer is here to correct me if I misconstrue his words, but I believe he was lamenting the limitation on the legislative branch when it comes to passing policy related to curriculum. And it immediately made me think of various themes we've heard throughout the last 2 days of how the 100 delegates were able to come together, put aside partisan politics, and work for all Montanans. And the flip side of that is how volatile our politics are today. And when Representative Mercer made this comment, it made me think of state legislatures elsewhere that are passing legislation and otherwise working to ban certain books from school libraries or, limit the type of history we teach our K through 12 students. So I was hoping maybe, Bruce, you could comment on the delegates' reasons for limiting the legislature's power with respect to public education, and if the other panelists want to comment on potential dangers of delegating more power to the legislature when it comes to governing curriculum.
Well, sure. When this came out most strongly, it was certainly in the constitutional autonomy, so-called, of the university system. That is, there was this kind of a search for which were the best examples in the country of universities that were named in the Constitution of state constitutions. And it turned out Michigan and California, which are two of the great university systems in the country, had that so-called constitutional autonomy, meaning they were shielded from a huge amount of legislative interference or other interference. And so I think that was probably the best example. In other areas, I wouldn't say there was a strong emphasis in in shielding the education dimension of the Constitution from other kinds of interference, but certainly there was in the terms of the university system.
I would have to add that there was really very little change in terms of that, between that Constitution and this one. But what the delegates were very cognizant of was the importance of local control and the ability of local school districts to make those decisions overseen by a commonality that would allow equality of opportunity for all students in Montana.
I want to echo what Mary just said. Can you hear me? I don't think the legislature has the constitutional right or authority to dictate curriculum. I think that is an issue for the Board of Public Education and local school boards. That's where those decisions are properly made. Once the legislature starts intruding into the rights of local school districts, they are overstepping their authority under Montana's Constitution. That's my firm opinion.
If I might, I must respond to this as well. I must say I agree with Mary. I think it is clear that our 1972 Constitution. Well, it won't last. Our 1972 Constitution, my read of the transcripts was it is clear that that we wanted to retain the concept of local control, and I see that as being applying to curriculum as well. I would argue that because the Constitution directs the legislature to provide a basic system, which the Board of Public Education then will generally supervise, one might argue that if you provide a system, you are opening the door for at least some intervention in the area of curriculum or in terms of what the goals are. And in fact, there are statutes that go to that. But I think at the end of the day, curricular decisions should be made at the local level with minimal interference and only guidelines provided by the Board of Public Education. This is where Mary and I may not agree.
All right, we are at time, I believe. We're in a tight turnaround for our next panel, so thank you very much for joining in, and I appreciate you.
I'm not going to drive home.